Thank you all for coming back. Are you fed? Yeah, I'm gonna do you right. You're gonna get some food, for sure. I am, first of all, just thrilled with how the morning went, and know we got a little bit off time. I hope you're thrilled too. But we are in a law school, and I am a lawyer. And, it matters, our ability to not just talk to ourselves about these important issues, but to make sure that the people who are presiding over the hearing of these cases are equipped with the information that allows them to evaluate the claims that we make in full context. And many of us have had the experience where we have seen judges who clearly don't know this important history, this context, the text. We heard earlier Donald Sherman say that the Supreme Court in deciding Trump versus Anderson was small. They couldn't big themselves up for the bigness of the 14th Amendment, and so they made the amendment small, right? They could not conceive of the vision of the framers and what they were trying to accomplish and what they faced. And I thought that was just such an important and powerful example of the challenges that we face when we come before judges who are not equipped with this history. I often send questions to members of the Senate Judiciary Committee asking them to ask nominees certain questions. I asked them to ask nominees, when was the last time you read Brown versus Board of Education? I asked them to ask, what are the 5 sections of, or how many sections are there of the 14th Amendment? Who is Charles Bingham? These are things that I think that judges should know. And we were talking about it last night. I have said this also with those who become or who are nominees to be our Attorney General. As I shared with the folks last night, our Justice Department was created in 1870 in part to give the federal government an arm to prosecute and protect the rights of Black people, right? They created the Justice Department just as they were passing the Ku Klux Klan Acts, the enforcement acts, to protect Black people against concerted violence that was designed to undermine their constitutional rights. We don't behave that way with the Justice Department. We talk about antitrust and all kinds of stuff, and then it's like optional whether you're going to enforce civil rights, when that was really the purpose of it. So I am always asking when we have AG nominees, ask them, do they know why the department was created, when it was created, what its initial portfolio was, and so on and so forth. And I think if we're equipped with this knowledge, we're in better shape to be able to press against those who are decision makers, whether they are Congress or whether we are making our arguments before judges, demanding a level of scholarship and knowledge that is necessary to resolve these cases. Fortunately, we have with us today 2 extraordinary judges who I just admire so much. The first one is one I've known for some time, Judge James Wynn of North Carolina. I think I knew him when he sat on the North Carolina Supreme Court and the Court of Appeals, back in the day, before he was nominated to sit on the 4th Circuit Court of Appeals, where he has sat since, how long have you been on the 4th Circuit? 2010. 2010. He tried to call himself retiring, but no, sorry. And you really have to read some of his decisions. They're just quite extraordinary. In fact, I'll try to talk about one today. And then my new friend, and when I say new, it's a few years now, but Judge Carlton Reeves is such an extraordinary, extraordinary jurist. I came to know him first from a very powerful opinion that he wrote from a lawyer challenging the flying of the flag with the Confederate symbol on it in Mississippi. I later knew him to write other decisions that I thought were incredibly powerful, including in the qualified immunity space. I met him in Jackson at some point. I remembered the work that was done by some of my colleagues to get him confirmed to the federal bench. And so I'm just always so proud to see him. But he's a judge who speaks through his opinions. And one of the things I think it's important, and I always show my students, we read his decision in Jameson versus Herndon, which is a qualified immunity case, is that judges have to comply with whatever the law is, whatever the court above them has decided, whether it's the Supreme Court or the Court of Appeals. But that doesn't stop judges from saying and speaking the truth in their opinions. And Judge Reeves is a great example of that. And so what I wanted to do was talk with both of these judges about how judges learn, and I want to point out that we're also joined by Judge Roger Gregory, the former Chief Judge of the Fourth Circuit Court of Appeals, who I've invited up here, but who's sitting in the middle of it. Wave your hand, Judge Ferguson. That, yes. And we're so proud of him. We're just so proud of him, of Virginia. So let's begin this conversation, and if you just get completely like in your feelings, Judge Gregory, or outraged, and you just want to come on up. Please, a round of applause. So I wanted to begin by asking each of you how you learned about, I wouldn't even just say the 14th Amendment, about Reconstruction, about the Civil War amendments. Tell us a little bit about your education, your schooling, where you first heard these concepts and the context in which they were presented to you, and how you refined your learning over time, not necessarily as a judge, but just as a man, particularly as a Black man in the South, how you developed that knowledge. And then talk about, like, as a judge, what you have kind of seen of how this learning takes place. And so why don't we begin with Judge Reeves?
First of all, it's an esteemed honor to be in this place. I was here for the Wiley Bratton series last year, and we talked, and I talked specifically about who who I've quoted others as saying, the founding father of the new America.
Yes.
Thurgood Marshall and those others who used these words of the 14th Amendment to put me in the place where I am today. So always honoring that and respecting that. I guess my story really starts back to the first grade, because there was a case called Alexander versus Holmes. And in these times, I talk about the value of having plaintiffs. Lawyers have their responsibilities. But there was this plaintiff named, and I'm from Mississippi, so I'm sure, and I've never met her. I'm sure her name is Beatrice, is what we probably call her. But she's probably Beatrice somewhere. Miss Alexander brought a case against the state of Mississippi, and well, her school district, Holmes County, and there were other cases, companion cases, the Singleton case. That case went up to the U.S. Supreme Court in 1969 because Mississippi had not enforced Brown. 1969 students, 1954, 1969. So those students who were in segregated schools then, when they came back home from Christmas break, they were brought into an integrated environment. Move forward to September 1970. That's my first grade year. All the students in Mississippi, this is the first time Black and white students started out in the first grade. So I realized growing up that white kids were just as smart as us. that not only did they have struggles trying to learn how to write in cursive, doing the fractions and all that kind of stuff, you know. So that's first grade, and I knew, because I had white friends. And in fact, I have I'll show you that later, a picture of us. So that's it. So let's move forward to the 9th grade. In Mississippi, each kid had to take Mississippi history and civics every year. In the 9th grade. And you took one semester and took the other semester. So I'm not sure which semester I took Mississippi history, but I was taught Mississippi history by my football coach. And we were studying out of the John K. Bettersworth book. It was the only one that was authorized by the state of Mississippi. A lawsuit ultimately was filed by a couple of professors at James Lawrence and some others at Tougaloo, conflicts and change. They had to sue the state of Mississippi to even bring in the real perspective. But John K. Bettersworth was a racist sort of depiction of Mississippi. So we got to Reconstruction during that period, and the teacher talked about how black people could not govern, how they wanted to be slaves because they could not handle freedom because they had everything given to them. Clothes, houses, and everything of sort given to them. So they did not, so they could not handle freedom, they could not govern, and all that. That was my view of Mississippi history. I went on to Jackson State University.
Oh, it's happening fast. It's going fast. Oh my God. Love it. Love it.
Come on. So I went to Jackson State. The most, I realize I'm on hallowed grounds, but I went to Jackson State, the most prolific HBCU in the country. Okay, no. So it was there that I studied political science, pre-law, and history. That's where I learned it. That's where I first learned the truth about even that happy time when I was growing up in Yazoo City. I learned that my 12 years was not so happy. I mean, I learned a lot about my own community and my own people around me there at Jackson State. And so from that point forward, I started trying to learn as much as I could from a historical perspective, what was going on. I majored in political science and with a pre-law concentration, but I took a bunch of history courses. And I got a chance to learn who I was and what history what I had not learned so much in my formative years. And I've continued that yearning by reading, by surrounding myself with very talented law clerks, some of whom have been from this court, some who've studied under Cheryl and Eichel. That's one way you can figure out what the Reconstruction amendments say. But that put me on that Jackson State and even at the University of Virginia. And then this other piece that caused me to really delve down into it was in law school, reading Leon Higginbotham's In the Matter of Carlton, and then Shades of Freedom. But reading that put me in the concept of thinking about what the 13 colonies, which he only talked about the 13 original colonies. He didn't really talk about Mississippi. Made me yearn to find out. I know Mississippi was doing even worse, right? So it was that. It was that. And as I became a lawyer and as I was in law school, I became aware of Judge Higginbotham's the Union case, where he was actually recused himself because he was black. And he wrote this eloquent opinion about using history and using that. And so that is what makes me know that it's completely all right to tell the truth in history and all that. But that's the dot from Yazoo City up there to reading that case and making sure that the truth is always told in all of our writing.
You know, I thank you so much for that, and I think about Judge Higginbotham, A. Leon Higginbotham. I was a summer clerk for him in law school, and that's how I got exposed to In the Matter of Color, and what it means when someone of that stature, this is a brilliant, brilliant, brilliant federal judge, Third Circuit Court of Appeals, should have been on the United States Supreme Court, was a historian, a scholar, but wrote in a way that was accessible for us, and how powerfully that can influence and shape us going forward. And he was a judge. You know, I just want to say that because, like, you know, because you're doing it now, and people are reading what you're writing, and it's freeing them up to know that they can say the truth and believe what they need to believe. Now, I'm tempted to move on to Judge Wynn, but the way Judge Gregory came, the way he came, now listen, Judge Gregory, here's the thing. He said, I can't cut you off. That's what he said.
He won't do.
You gonna respect the time.
Absolutely. Based on the time has been respected so far, I have plenty of time.
Sat there quietly, sat there ever so quietly. I begged him, join the panel. He said, no, I don't want to. Let's leave it to them. You see what I'm saying? Okay, so I'm gonna let Judge Wynn go first because I don't know what's gonna happen. Okay.
Well, I promise you I will seek to be a bit briefer than my colleague on the trial bench here. I echo what others have said here. Shirley, it's a pleasure to be here with you, and I sit in honor of the years and the work that you do and the commitment, and also to Howard University, this law school here. You don't know how much study I've done here in terms of the work that's done. Particularly, I've been fascinated with the life of Charles Hamilton Houston. Gina Ray McNeil has written the biography on him. He was a professor at UNC, and I've written on it. And one of my wonderful professors, by way of just giving an idea at UVA when I was there working on the master's, he told this story of how it started with Rudolf von Ewing in Germany, and this is whole idea of this sociological conduct that can arise from changing laws, and that Roscoe Pound became enamored with this, he being a botanist and compartmentalizing things in different areas, and he happened to have this, and I'm really short-circuiting this thing, this favorite student of Hamilton Houston, and Hamilton Houston at a time when Frankfurters and others with Harvard, a whole bit, and in his words, he said, they sent him to Howard to Harvardize Howard University. I don't know what that meant, but maybe it was a case law study he was talking about. But the fascinating thing about it was, contrary to some of the comments made earlier today, that things happen by happenstance and you start out and you don't know how it's going to end up. I submit to you there is the view that Hamilton Houston was intentional in everything he was doing. And in his word, it was said that Brown was being argued at this law school 20 years before it got to the court. And they had those series of it, and they built it up through the ranks because they couldn't go directly into the school system because you can't segregate little kids like that. You can go after teachers' pay. You can go with Gaines versus Missouri. You can go to Sweat versus Painter down in Texas. You can build up the ladder, and by the time this word called precedent and stare decisis took over when you got to Brown, the case was won on it. But I didn't have people just read the 14th Amendment when they were clerking for me. I actually had them reading Richard Kruger's book, Simple Justice, until Jack Greenberg, who I was with some many years ago, told me his book was better. But the reason was because I wanted my clerks and others to know that law is more than just coming to the appellate court and arguing a case. Yes. The case is built down in Clarendon, South Carolina. It's built on the grounds of interviewing witnesses. And I said I wanted them to know what it's like to be a lawyer in an office, and a group of clients come in to you with a case of constitutional proportion of which they are absolutely right, but the daggum Supreme Court is absolutely against you. How do you get that case to the United States Supreme Court? It's just fascinating to me. I'll be a little briefer in terms of my history, but I will say this. I pulled a quote in writing an article on, it was that time, diversity and accountability, from Scalia, of all people, and this was on the Minnesota versus White case, the judicial speech type case, and he said this one quote, and I say this to you, that everything I see that's written, there's something in it that favors going the other way, and you ought to play with that. You ought to go with it. But he said that one quote. He says, judges don't come to the court with a tabula rasa. They don't come with a blank slate. And I said, thank you, Justice Scalia. You've just indicated why we need diversity, because everybody comes with different perspectives on it. And when Judge Reeves began with his early background, we bring those perspectives to the court. It's a difference. There's a judge I won't mention who's a strong colleague of mine, and he tells me, he says, Jim, I was born with a silver spoon in my mouth. He's not kidding. He was. And so many times we were talking, he doesn't understand what it is to be in a tobacco field or to watch a man walk behind a mule all day long with a plow, or to be in a segregated institution and to deal with it. And sometimes importing that experience into the decision-making process is important. Why did I decide to go this route? I started out in the segregated world when schools were segregated, and I was in a segregated school up until 8th grade. There's one thing Brown got wrong. He said that it is inherently unequal. That's not true. Segregated schools were not inherently unequal. There were a lot of factors involved into it. But the fact of the matter is, in many ways, the education that was provided by the kind of professors and the people who were teaching them was superior. I mean, when I asked my friend Bill McNeil, who was the black superintendent of Wake County, I said, well, they're resegregating the schools, and so it's probably going to be good. He says, no. He says, when you were segregated, John Hope Franklin was teaching in the black school. he said you would have Charles Ogletree teaching you. He said, you don't have that now. So it's a whole different thing that's going on. But the other emphasis that I point out is, athletes has always been great. And now, you put down kids who were at the top of the class. When I was in school, the top students were the heroes at the school. And they promoted it everywhere you go. People just naturally just say, that's the tops. One of the first, I was in the band for a couple of years, and the band director got as mad as he could be with me one day. And he says, you first in the class? It was like I was playing basketball for a top team or something. He was really mad about that thing. But it was all from the concept that W. Du Bois brought up in terms of moving upward, that upward movement that was instilled in our parents and those who saw the way out as education. And it was a way in which to move forward with it. Law came about, now end with this and give it over to someone. I'm telling you, this is my chief judge for life right here, Roger Gregory. And he and I, we serve on the same court. We don't agree very often, do we, Judge Gregory? But I think that what amazes me about being a judge is you say, how do you learn? They put a robe on you, and you're an expert in everything.
Everything.
Literally. You don't know a thing in the world about an immigration case, but it's before you. You have no idea what an ERISA case is on it. It's before you. And how do you get there? The technical answer is it really should come from the record. It's before you. The litigants bring it, put it in the record. But nowadays things come in different ways, and you've always had treatises. I took the word that Prosser on torts was a law, a word. But it turns out Prosser's a man like everybody else. He's writing his opinion and just like that. So you have to balance that off. I've known judges to consult professors and people outside. You shouldn't do it ever without informing the parties that you're doing such a thing. But now you're in a whole bold new world, and maybe we'll talk about it, and I'll leave you with this thought. Everything I've heard today is wonderful, but I'll tell you this. The world is not what it used to be, and I was asked that question recently when I was speaking to a group, somewhere in Northern Virginia, and it says, why is everybody so apathetic, and why are you not doing it? I said, because the world's not what it used to be. You can't these children coming up now didn't grow up with this experience that we have. They don't know these things. And they live in a totally different world where street marching is not the answer. The way to communicate is social media. There's something going around right now, and I guarantee everybody here shake like you're not using, but I guarantee you're using AI. And it's all over the place. And it's changing the world and the world in which you live. And when we were doing the gerrymandering cases, and I wrote 5 of those decisions, one of them was a Rufjo case that said that partisan gerrymandering couldn't be used, and of course the Supreme Court said it wasn't justiciable. I don't figure that out. And because Chief Justice Roberts, in another case, said that that science was gobbledygook. Well, you know that gobbledygook science is what they use to gerrymandering. Those algorithms are how you draw the districts, and they're doing it with such precision, that term we use there, surgical precision. It's coming out through the science and through the technology. So we have to move our focus away from traditional thinking into where we are in 2025 and deal with the science and the technology that not only the different generations are using, but is really impacting the way in which we approach issues.
Absolutely. Judge Gregory?
I told you we'd have enough time. First of all, Shirley, thank you so much for letting me be a part of this impromptu as that, this August body. And I was just thinking, the three of us sitting here, do you know how close we are to, if I was still the chief of the Fourth Circuit, Judge Wynn, I could invite Judge Reeves to come and sit with us as a visiting judge, and we could be a panel on the United States Court of Appeals for the Fourth Circuit. And I was just thinking, I think since we can't do that, what better place to be than at Howard University Law School?
Chief, I'm not going to accept it can't be done.
And I have to say this, that if you see a turtle on a post, you may not know anything about that turtle, but one thing you do know is that someone helped her or him get on it. Let me tell you, Elaine Jones lifts turtles. And sometimes what we have to go through is good to have shell. You know, I grew up in Petersburg. For those who aren't Civil War buffs like I am, it had the longest siege in the history of American warfare. It took over 300 days to take Petersburg. Grant said, if it takes all summer. When Petersburg fell, a week later, well, the next day, Richmond fell, and a week later, the Confederacy fell. So history and that part about that has always been a part in the 14th Amendment. It's another Howard, and of course, Elaine is an undergrad Howard alum, and another alum from the law school, from the law school is my former law partner. That's why my start of the 14th Amendment was L. Douglas Wilder. And I was at the best HBCU, Virginia State University, then college. Go Trojans. And he was an adjunct professor. He taught me 2 constitutional law classes. And literally, when we were having an exam, he would open up his scheduling book, and we were close like a seminar. I'm sitting right across him. I could see in his book, not read it, I didn't read it. But I could see the appointments in the court. I just thought, wow, that would be cool to be a lawyer. And as God would have it in the alchemy of his hand, 10 years later, we'd be law partners with Wilder and Gregory. I'm talking about threads, young people. Threads. In the 14th Amendment, the connection is about threads. And sometimes those threads weren't laid out deliberately for you, and sometimes they were designed to be anybody but us. But somehow those threads got deep, and they were colored and stained by blood, sweat, and tears of people who came before. And somehow they knew somehow it would be better. And, you know, as a judge, I was on the Brown versus Board of Education Commission by the president. I was the Chief Justice appointed me. That was 2004. But I don't want to go through that, but what I'll never forget is this. I was invited to be the commencement speaker, of the second class of persons who were denied 5 years of education in Prince Edward County, and they received honorary diplomas. I'd never forget that as long as I live.
Judge, explain to them why they did not receive their education
Oh,
in
yes,
Prince Edward County.
Well, see, when Brown came out in 50, first of all, it's really cool history because when it was first argued, and then Vinson was Chief Justice, and he died, And then Earl Warren came on, and Frankfurter said, let's hear it again. And this time the question is, do we have the power to desegregate? Not about what interpretation of the Fourth Amendment. Do we have the power? But anyway, long story short, in '54 when it came out, it came out, well, wait for it. Took another year. And then when it came out, it was all deliberate speed. But in the time frame, for other people, it was anything but deliberate. It was very deliberate, but anything but speed. Prince Edward County decided, can you imagine somebody in the room saying, wait a minute, they said if you have a public school, then it's desegregated. What if you don't have one? And that's what they did. They took the funds out of the public schools, and for 5 years, from 1959 to 1964, about 60 miles west of where I live, talking about geography, had I lived 60 miles west, I would have been in there. So I was seeing classmates that day. I went to school in '59, but they didn't. They were my classmates. So there was that, and tears were in their eyes, and these were grandmothers and grandfathers, and their grandchildren were, that it was a riveting moment. That's why the 14th Amendment and those things are so precious, and because it's real. People with boots, people who didn't know what Fourth Circuit was, prayed for me, supported me, did those things, and I mean, Lane and Leslie Prohl and people like that took a chance on this little boy from Petersburg. And, so the 14th Amendment is so real. And I just, real quickly, I just tell you this, the reason why I say this, because I was born in Philadelphia, but I know nothing about Philadelphia. It must have been 2 weeks and I was in Virginia. That's because, how many of you have seen the movie Antoine Fisher? I lived a scene, the one with Viola Davis, one of my favorite actors. And the scene was this. I never knew my birth mother. And so I was born with asthma, rickety legs, and burn, and God has taken away any memory of any pain of that. But can you imagine my adopted parents, my parents, that you lined up 10 children in a row, little babies, about 2 months old? Who would have picked a child with scars, rickety legs, and asthma? That's what I'm talking about. That's what the Fourth Amendment, in finding and deep you students, there is place for room to live out the true meaning of those words and make them live. Live for an idea of freedom and justice and equality. And those are what the forebears do. And whatever that language is, Judge Wynn, we have to interpret it and help young people and let them help us too do those things. It's, every day, I'm going to end up, but, every day I go to work, I go to a courthouse. Don't tell them about this. I have more square footage than any judge in the world. Now, if you tell anybody, I will do a bench warrant on you. I'm telling you. But no, I'm the only judge, 4 floors and an annex. I'm the only judge. I only see my colleagues, my dear colleagues and friends, 6 times a year, and exclude the 3 or 4 months of summer. So I live a very lonely, lonely time. But I love it, though, walking those halls. But the point is this. The building was built in 1858, right? It was a federal customs house. What happened 3 years later? The war. It was the treasury of the Confederacy, and Jefferson Davis had an office in the building.
Yeah.
And they said that his ghost is still there. So I walk around at night, I've been looking, I have not seen him. But if I do see him, I'm going to put him to work. But I will pay him a fair wage. But I don't think I'll put him on a Title VII, because that may be a conflict of interest. But the point is that, but every day I think about that, and I look out to see the Capitol that was designed by he did become president, but he was the governor, second governor of Virginia, is Thomas Jefferson. And all of this history that speaks over time, but there are some things that must be mutable. Something that it must live. And the life comes in terms of the bench, in terms of adjudicating the law, and these young students and other people who listen to panelists and the work that they do, you make it come alive. And that's what refreshes me, and I love history. So I write, and read a lot of things about the 14th Amendment and what his original plans were. But the thing about get me the most about the 14th Amendment is what the Supreme Court did post-Reconstruction, Slaughterhouse, Cruikshank. Oh my
rights
goodness, the
cases,
civil rights cases, and in Locke, just the whole idea that the corporations were more. I mean, so, and that's a whole lot to unravel. And I'll finish with this, and that's what inspired me too when you mentioned Alexander Holmes. Real quick, and I'm gonna finish it with this. In 1961, a young, dashing Bostonian told America, before the end of this decade, we will send a man to the moon. He said it in 1961. Brown, in 55, came with an edict, but all delivery speed and end segregation in schools, legal segregation. So with a head start of 1955 versus 1961, man walked on the moon July 1969. Alexander Holmes was in October of 1969. Man walked on the moon before little colored children and white children could go to school together under Brown. 14th Amendment must live, and there must be something about deliberate speed and making it real. Thank you.
You knew you had to be up here, come on. That was fantastic. Each of you have provided a window into, how you developed as men, as black men, and how that experience and that development bears on who you are as a judge. Now, you all know that I've written a lot about the importance of diversity on the bench, of ensuring that there are black judges, that there are women, and the Legal Defense Fund worked very hard on that issue and continues to work on that issue. But I want to talk a little bit about how your colleagues learn. I often cited in my writing the Stanford Law Review journal that was devoted to Thurgood Marshall after he retired from the bench. And in that Stanford Law Review volume, many of Thurgood Marshall's judicial colleagues wrote very beautiful essays about him. Sandra Day O'Connor, Justice Byron White, Chief Justice Rehnquist, for heaven's sakes. They all wrote these lovely encomiums to Thurgood Marshall. And many of them talked about the stories that he would tell that came from his litigation experience, that he would tell in the conference room. Now, what I always remember, something else that I quote, is that Thurgood Marshall said about his colleagues on the court, none of them knew anything about black people before I got there, not one of them. But they talked about the stories that he would tell. Justice White said, he told us things that we didn't know and perhaps that we didn't want to know. And O'Connor said he told us things out of his experience. He would say that, he would talk about what it means when a sheriff in a particular state or county says that the person confessed immediately to the crime, and what kind of pressures might be brought to bear. He talked about a case where a black man was accused of killing a white person and the jury gave him life, and Thurgood said, that's how I knew he was innocent, because they didn't give him the death penalty. He knew things about our justice system that they didn't know. And I used to quote it all the time, and then I got to a point where I thought, where did any of this show up in their opinions? It's nice that he was telling these stories, and that apparently they were hearing them. But it wasn't clear to me, I can't point to a decision by Justice Rehnquist or Justice White or Justice O'Connor, for that matter, that demonstrates, that reflects that Thurgood's stories kind of got in there somehow and shaped their thinking. And so so it had me rethinking my thoughts about diversity. Not that, of course, we need to have diversity on the bench, but one of the benefits of it, I thought, was the interplay that allows judges to influence each other. And so I guess I want to not put you on the spot, but put you on the spot to just, without any names, please, just to talk a little bit about what you think is the possibility of influencing your colleagues from your experience? Because you come with a whole lifetime of experience. One of the most powerful decisions of Justice Reeves, one of the most powerful decisions that came out of the Fourth Circuit, were both in cases of police killing unarmed black men. And if I'm not mistaken, they may have both been in 2020. I know the Fourth Circuit one was because you all said this has to stop or something like that. And we were in the midst of it. At that time, I was at LDF. And that decision, was like contraband for us. We were passing it around like judges here, they're hearing us. They feel this thing. You have no idea. Even though you had to follow what the Supreme Court has said about qualified immunity, just hearing those words articulated, hearing Judge Reeves reading his opinion in Jameson, which I have my students read every semester, and having him, just the beginning of the decision, about the client in this case, and using every case involving police violence to say, this was not that, this was not that, this was not that, this was not that. We felt heard. It mattered to us that judges were saying this. But you all were saying this. And we were not, we didn't fool ourselves, right? We know which judges are saying it. Now, interestingly, a number of conservative judges have been expressing their concerns about qualified immunity as well, which has been really wonderful to see. And so there is a kind of cross-ideological concern about qualified immunity, which has been used increasingly to almost fully immunize police officers for the use of deadly force. But I guess I just wanted each of you to say something about what you think happens, on the bench, in the conference room, in terms of your conversations with each other, and whether you believe your colleagues who are fully grown people, fully grown lawyers by the time you interact with them as judges, are they open enough to learning from you what you know that they don't know and perhaps don't want to know?
Well, I would say, Sherilyn, I think you have made an assumption that most lawyers and most people will make, and that is that that opinion you're reading is that it looks just like it was the first time it was circulated. I have written tons of dissenting opinions, a whole lot of them, on the State Court of Appeals, the Supreme Court, and this court. I have no problem writing a dissenting opinion or a concurrent opinion. And sometimes when I've written them, they don't turn out to be a separate opinion because they're folded into majority. I have seen it countless times where that opinion starts out, and whether it's Judge Gregory writing it, and I promise you I write no more dissents than Judge Gregory. We write these opinions, and the majority responds to it, and they improve the heck out of that opinion. If we weren't there, you would see some law that you probably really wouldn't want to see. So don't assume that the final product that comes out of there is the same. Almost never is it that a dissenting opinion is made and a change is not made in that majority opinion. And sometimes we point out errors because the facts of a case are what the judges say they are. Who goes and checks the record to see if those facts are correct other than the litigants? But the dissenting opinion holds them truthful and accountable to facts and to law, and often forces it to address the issues that are there. So the influence of having someone with a diverse experience, and then there's the whole business of the whole American jurisprudence system. You write it down, and when you write it down, they don't just care what their political colleagues think, they really care what the scholars think. And if I've had cases where a dissenting opinion was written, and then all of a sudden, people like you, Sherilyn, who in these high towers, write scathing opinions about the majority or something, and I know it's affecting them. And
This
because
is really
those
the most important thing I wanted to hear today.
those are the people, it makes a difference. They care about how you view them, and because you are their colleagues, you are their peers. And I will say, and I'll end this, the difference with, and I'm not putting down the state court, I was elected judge on the state court, statewide election. Anybody could run. All you needed was a law degree, literally a law degree is all you need. And sometimes anybody did run. and you had all types on the court. But I'll tell you what, you might not like this vetting process that goes on this federal court, but these are no dumb judges. They are smart. They may not agree with you or you may not agree with them, but they are really, really smart. And then when you go and Judge Gregory and I go hire guys like Chico there, my law clerk. Unreal. He's so smart. When I walk in the room, I feel the electricity going on. And you got that around you, and everybody's got that in that crucible you're talking about. And it is just all over the place. So don't think that what you see is just a raw product of what they want to write. And sometimes the issues aren't even addressed. Qualified immunity is a good example to it. I'll let Judge Gregory talk about that because we've dealt with that. But sometimes you avoid issues. You might call something harmless error so you don't have to deal with that issue up here. Or you may change something in opinion. So diversity makes a tremendous difference on these courts. And don't you for 1 minute think that just because you don't see that final opinion being what you want it to be, you are fortunate it does not say something else up there.
Wow.
Well, I think Judge Wynn said it a lot, and I agree with a lot of what he said. Your influence in terms of diversity, it's very important. I think the idea, first of all, letting your colleagues know that you see it differently. And it's hard to answer your question, Sherilyn, without breaking my rule of complete modesty and humility. But no, it really is. I'm serious. No, but if you look at, because I mean, defense lawyers say this a lot. You see them at the grocery store. Really, I'm sure they say, Judge Gregory, your case, I could rattle off a bunch of them in terms of Fourth Amendment cases, in terms of stop and searches, and that is let your colleagues know just because you call this a high crime neighborhood, does the Fourth Amendment, is it suspended? What would this opinion look like if the facts were in another section of town? Would you be satisfied just because you lived on this street, you're encountered when all you're doing is just trying to go a distance? And I had a case where the man was shot 22 times by the police officers, and I'll never forget that he said he was just going down the street. He said, "I just want to go the distance." In a matter of about a few later, he was dead. But you let your colleagues know that you've lived some things, that you've seen some things. You know, life ain't been no crystal stair, like Brother Langston said. It's been boards and tacks and all torn up, but I kept climbing. I remember one time, I won't say what it was, I was on the court, and I was dissenting, and one of my dear colleagues said, he or she, I'm trying to be anonymous as possible, and said, "Well, Roger, I'm so sorry you were able to join us. Maybe next time you will." I didn't say anything, and I looked at him, and I used the same soft, inviting voice, too. And I said, no, that's okay. I hope next time you'll be on the right side. He never said that again to me. Because there's no domain of right that anybody controls. We learn from each other. Everybody's my superior in that I may learn from her. And they have to understand that. And that's where your diversity is. Wait a minute, how do you get to that? And one thing about it, I like because our colleagues are smart. Because you say, wait a minute, how do you justify this? I mean, where is the roadmap to this? Sometimes I tell my law clerks, sometimes when you write a dissent, the best recognition you'll get is the sound of a one-armed man clapping. But that's okay, I didn't come for affirmation. But yeah, it does, you're right. It changes what opinion first looked like. So you actually have to take that out, because what justifies that? Because then the A personalities come out. That's what you're gonna write? Well, you'll see my dissent, and I'll try to point to you where the problem is with that. Well, what do you think? Well, let me send you something. Let me send you 5 pages that might be able to. You see, that's where it is. In other words, I love this old proverb. It said, everything is possible as long as you don't care who gets the credit. For example, there was a big case that everybody knows about. I'm not going to mention it. I know you know the case. I was the lead judge, and I could have written it, but the person who wanted to write it would be better coming from him, you see what I'm saying, than me. Because, Gregory writes that. No, but you see what I'm saying? So you increase your territory by giving up ground when you know it's good ground and it's good soil, it's going to grow. It's not for you. So yeah, that's where the influence, I think, it is.
Thank you. And Judge Reeves?
The only thing that I'll say is, I'm a district judge. so I don't have to get the vote of a second person. And that empowers me. That frees me up to say the things that I think need to be said. And Ms. Eiffel was right about the Moore versus Bryant case. It was the Confederate flag case there in Mississippi. That was my opportunity to not only speak to me about what I learned in the 9th grade, that was to speak to everybody else who had taken Mississippi history. And so we went through, we said, no, the case is non-justiciable, political question or whatever, but we need to address this anyway. Dismiss for standing, excuse me. But we need to address this history and put forth the other version, the true version out there, so that it could be cited as what the truth is. So you take other cases and opportunities to say things. SEC versus Adams is another one. Had an opportunity to appoint a receiver. And so I went through this notion. I said, you know, the SEC had recommended a receiver because this is a case that they brought, and it was a white guy out of Florida. SEC, the regional office is out of Atlanta. They recommended a white male lawyer, I think, from Florida. And so the Secretary of State's office in Mississippi says, oh, by the way, Judge, since they recommended somebody, we got our white male too. That's what, I mean, basically, we got our guy who had been appointed by the court a number of times. And so I said, okay. I said, what about if the court opened this process up? And I did an opinion about opening the process up because there's much literature and stuff out there, other courts, how MDLs are all headed by steering committees, all by males.
That's multi-district litigation. but-
Right. And other instances, well, those appointments are made by whom? Judges. Judges are the ones who appoint bankruptcy judges. And we know what that looks like. Judges are the ones who appoint magistrate judges. And judges have the power to make sure that the representation of the population is in all this. So we decided to write, again, just on that. And then, because I don't have to get a second vote, and none of these judges either, about how can you sort of by example, because I don't have to sit with anyone. But my chamber staff is always diverse. My chamber staff is always the best staff that's in the courthouse. And they see that I can operate holding 2 jobs, for example.
Because he also chairs the Sentencing Commission, the United States Sentencing Commission.
Yeah, and so you sort of do it by showing. You don't have to say much. You deliver. And so again, there are many other opportunities where a district judge has that opportunity to set the table, if you will, for the next level.
Can I just say one thing because you're being modest? First of all, any of Judge Reeves' clerks who are here, would you just raise your hand? Where you at? Outside. Judge Wynn's clerk, Chico. Judge Gregory, did you bring any clerks with you? No. You didn't need them.
My former law clerk was on the panels.
Oh,
Sure will.
I'm just saying.
to say.
And
LDS
two of your former
finals.
clerks just went to the circuit court.
Gentlemen. I wanted to be sure to say this about
just want
Judge
the
Reeves
history to be
because
right.
he's being very modest. The elephant in the room is that the other reason that some judges, district court judges, will not write the truth that you write is because they dream of being circuit court judges or because they dream of being on the Supreme Court. Now, that shouldn't necessarily stop you, but if you let it stop you, if you decide that you are going to restrict what you say and write because of your own ambition, and that's the other thing to recognize is that judges have ambition too. And so your decision to write in that way is in spite of, right? I mean, you'd like to be on the Fifth Circuit, right? But if you are called to be on, but if you are called to be on the Fifth Circuit, you will go. Elaine? Listen, thank you all so much. This was such a wonderful conversation. Please give a round of applause for these judges. Y'all are too much.